have two cases on the docket this afternoon. The panel, my name's Robert Wiedemeyer. I live in Nashville. On my right, Judge Camille R. McMullen from Memphis. And on my left, we're fortunate to have with us Judge D. Michael Sweeney, who is a member of the Court of Appeals, who has agreed to sit in with us on this case due to a conflict that Judge Hickson has. 20 minutes per side. If you want rebuttal time and you're the appellant, tell us going in. Clerk has done a great job of keeping up with the time, and you can, when you see the yellow light, you're just about done. When you see the red light, you should stop talking if at all possible. We had a couple people run red lights this morning, but we're still okay. So, are there any preliminary matters for the afternoon docket?
No, Your Honor.
All right, thank you. Call the first case.
State of Tennessee v. William C. Sutton.
One announcement also is that I made this morning, and it applies this afternoon. We have read the briefs on these cases, so we're prepared in that respect. You might want to tailor your arguments accordingly. All right, we're ready.
Good afternoon, Your Honors. Jackson Fenner from the Knox County Bar. I'm here on behalf of the appellant, Mr. William Sutton. I will keep it brief. In this case, the trial court entered an exhibit that was purported to show that my client, Mr. Sutton, was banned from Walmart for life. And we objected to the entry of that exhibit on the grounds that it was hearsay. It was prepared by a person other than the person that was testifying in the trial court, not the witness. The word life was written on the document, allegedly indicating a lifetime ban from Walmart. The witness, however, on the stand, was not the person who wrote that word, the word life on the exhibit. So that word itself is hearsay within the document, which is also hearsay. The state did argue that my client signed the document, but it's our position that the person who prepared it is the proper person to bring in the exhibit, not another person who was in the room when it was signed. It's an improperly entered exhibit as hearsay. So without that exhibit, the state cannot prove that my client was on notice that he did not have consent to be in the store. So without that exhibit, which is really the whole crux of the state's case, there is insufficient proof to prove the charge of burglary, which is what he was convicted of. So our position is that the court erred in allowing that exhibit in, and without that exhibit, there is not sufficient proof to prove the charge of burglary. Thank you. And I'm sorry. I'm not trying to cut myself off. If y'all have, if your honors have any questions, I'd be happy to answer that.
I think so. Thank you.
Okay, thank you.
All right, General. Good afternoon, sir.
Good afternoon, Your Honors. May it please the court, Johnny Saraceno on behalf of the state. Petitioner was charged with burglary, and then after trial was convicted and was sentenced as a career offender to 12 years in TDOC. Regarding this trespass notice, it stated in very clear terms, and this occurred prior to the incident, that defendant was banned from Walmart, which is established in part through this notice that it says very clearly, quote, "This document constitutes formal notice and warning that you're no longer allowed on Walmart property or in any area subject to Walmart's control." And then there's a clause that states, you know, I read and understand what this document entails and what it means. And defendant signed his signature to the bottom of the document Prior to trial, as my friend on the other side has noted, defendant moved to exclude the notice or the trespass notice as hearsay. In the trial court, it was discussed as hearsay. It was or raised as hearsay, sort of discussed almost like an authentication issue. But ultimately, the trial court said, well, there's a witness, a state witness, who said he saw this being signed, so this is not an issue, and allowed it to come in at trial. I've argued that it was an adoptive statement because the defendant affixed his signature to the document, and so it's not hearsay.
Is that argued below?
No, Your Honor, it was not really argued below. I think that may go into waiver potentially as well. This could be a waived issue. It was sort of ambiguous how the issue was raised and discussed. And that's why I mentioned it was sort of discussed almost like an authentication issue, even though it was branded as hearsay. Regardless, it's not hearsay. For the reasons that I just noted, has its signature that isn't really contested as far as I'm aware. And then again, the witness said, yeah, I saw the defendant sign this. And even if it was hearsay, it's harmless because there was a video recording that the state played where a person explained that to defendant that he was banned from Walmart, and defendant responded that he understood. It's also, the state's witness also said that defendant heard and had it explained to him the nature and meaning of the document, the nature of his lifetime ban. Regarding sufficiency, he was seen on video entering Walmart and taking clothing items without paying for them, and because of the ban, which was again attested to in 3 different ways, by the document, by the state's witness, and by the video recording the defendant, he knew that he did not have consent to enter Walmart's property. Unless there are any other questions, we ask that you affirm the convictions.
All right, thank you, General.
Thank you.
And Mr. Fenner, thank you for your concise brevity, and we see the issue, I believe, well briefed. We'll take it under advisement and get an opinion issued in due course. All right, thank you both. Next case, please.